Ready, start. Language of the provision makes it abundantly clear that there exists a strong presumption that the husband is the father of the child born by his wife during the subsistence of their marriage. Full stop. This section provides that conclusive proof of legitimacy is equivalent to paternity. Full stop. The object of this principle is to prevent any unwarranted inquiry into the parentage of a child. Full stop. Since the presumption is in favor of legitimacy, the burden is cast upon the person who asserts illegitimacy to prove it only through non-access. Full stop. It is well established that access and non-access under Section 112 do not require a party to prove beyond reasonable doubt that they had or did not have sexual intercourse at the time the child could have been begotten. Full stop. Access merely refers to the possibility of an opportunity for marital relations. Full stop. To put it more simply, in such a scenario, while parties may be on non-speaking terms, engaging in extramarital affairs, are residing in different houses in the same village, it does not necessarily preclude the possibility of the spouses having an opportunity to engage in marital relations. Full stop. Non-access means the impossibility, not merely inability, of the spouses to have marital relations with each other. Full stop. For a person to rebut the presumption of legitimacy, they must first assert non-access, which, in turn, must be substantiated by evidence. Full stop. These parameters have been subsequently followed by this court in Sarda versus Dharampal within bracket Supra and Bhavani Prasad Jena versus Orissa State Commission for Women within bracket Supra bracket close full stop. In these cases, it was held that DNA tests may be ordered, only if a strong prima facie case of non-access is made out, with sufficient material placed before the court to arrive at a decision. Full stop. In the case at hand, it is an admitted fact that when the respondent was begotten in 2001, his mother and Mr. Raju Kurian were married. Full stop. In fact, they had been married since 1989 and neither had ever questioned the validity of the marriage. Full stop. They were, admittedly, living under the same roof from 1989 till 2003, when they decided to separate. Full stop. It is, but obvious, that the respondent's mother and Mr. Raju Kurian had access to each other throughout their marriage. Full stop. This conclusion has been arrived at through concurrent findings of all the courts involved, at multiple stages of litigation. Full stop. Even if it is assumed that the respondent's mother had relations with the appellant during her marriage and especially when the respondent was begotten, such a fact per se, would not be sufficient to displace the presumption of legitimacy. Full stop. The only thing that such an allegation sheds light on is the fact that there seems to have been simultaneous access with the respondent's mother, by the appellant and Mr. Raju Kurian. Full stop. What, however, needs to be clarified is that an additional access or multiple access does not automatically negate the access between the spouses and prove non-access thereof. Full stop. Consequently, there is a statutory mandate that the respondent must be presumed to be the son of Mr. Raju Kurian. Full stop.